Greetings, this is Christine Van Pelt on Gibson County, Indiana, State Coordinator, Lead Recording Secretary for the Indiana Assembly. And we are continuing with Brent Allen Winters' Declaration of 76, United States Constitution, a Common Lawyer Comments, clause by clause. We'll go ahead and get this going. We are on Article 4. The framers got much of the language for Article 4 from the old Articles of Confederation, by which the general government operated until it began to operate under our Constitution in 1787. Section 1, Clause 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Comment. This full faith and credit clause follows the common law rule. For example, American courts, both state and federal, honor official legislation, court rulings, and records of foreign countries, unless these are shown to be unlawful or unreliable for lack of due process. This clause further requires each state to honor each of its sister states' official laws, court rulings, and records, unless shown to be unlawful or unreliable. To be sure, each state must honor marriages its sister states have declared valid in trusts settled in its sister states. It is beyond debate, however, that neither the farmers nor any other colonial ever had homosexual marriages in their contemplation while drafting and approving this clause. Moreover, their common law tradition holds such false marriages unlawful. Therefore, this clause never requires any state to recognize homosexual marriages, and reasonably so. The laws of nature's God have never recognized sodomite marriages. In sum, our Constitution bars any state or state official under oath to support our Constitution, i.e., protect it from domestic threat, from honoring any unconstitutional or otherwise unlawful decree or act of any sister state. Section 2, Clause 1. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Comment. This Privileges and Immunities Clause requires that any citizen from one state who travels to another state be entitled to all the privileges and immunities that automatically go to citizens of the state to which he has traveled. Some privileges, however, such as the right to vote, do not automatically attach to visitors, but require a period of residence, the will to register to vote, and perhaps other qualifications. The word citizen in this clause does not include government-created fake persons such as corporations. Clause 2, Section 2. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority from the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Comment. Under this extradition clause, if a person is charged with treason, felony, or other crime in one state and flees to another state, the governor, the executive authority of the state from which he fled, can demand that governor of the state to which he has fled to hand him over. Because this clause never mentions misdemeanors, some states refuse to hand over fugitives a sister state has charged with only a misdemeanor. Common law's due process entitles the fugitive accused of a felony to an extradition hearing to determine the lawfulness of the sister state's accusation and the likeliness of him getting a fair trial in the state demanding his return. Sometimes a governor or court will refuse to extradite because the crime charged was done many years before and the evidence has grown stale, precluding any fair trial on reliable evidence in the accusing state, or because the governor or court believes other reasons would prevent the accused from getting a fair trial in another state. Each state must judge for itself. Law against treason is a badge of sovereignty. By the extradition clause acknowledging the right of any state to bring charges of treason, our Constitution affirms the sovereignty of each separate state, thereby limiting the general government. Bottom line, the sovereignty of the general government ends with the list of powers the Constitution delegates to it and at each state's boundaries. On the other hand, the sovereignty of each state covers all within its boundaries federal property with any state excepted. Section 2, Clause 3. No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Comment. Amendment 13 supersedes this clause. A person held to service or labor was a slave or an indentured servant, a person having bound himself by contract to serve another for a fixed number of years. Amendment 13 bars any law or court in the United States from recognizing anyone's binding of oneself in slavery to another. Consequently, the foregoing clause no longer has any force. Section 3, Clause 1. New states may be admitted by the Congress into this Union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the jurisdiction of two or more states, or parts of states, without the consent of the legislatures of the states concerned, as well as of the Congress. Comment. This clause bars forming any new state by dividing or joining existing states or parts of them, unless the legislatures of the states concerned and Congress's consent. Congress relied on this clause during the years 1861 to 1865. The state of Virginia joined the Southern Confederacy, but people in the northwestern counties of the state chose to stay with the Union and split from Virginia. Congress, calling this clause into play, accepted these western adjoining counties into statehood, calling them West Virginia. But without Virginia's consent, Virginia said Congress, by her secession from the Union, forfeited her the right to withhold consent to the forming of the separate state of West Virginia. Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Comment. The word needful limits Congress's exclusive power over property belonging to the United States. This clause also provides a rule of interpretation for the entire Constitution, barring any construing of its terms in a way that will prejudice any claims of the United States or of any particular state. Since the earliest days of our Constitution, Congress has exercised this power over United States property to its full reach, Congress alone deciding whether, to whom, when, and under what terms it will sell, give away, or otherwise dispose of United States land and chattels. The courts and president have no right to interfere. Congress has given land to railroads and aircraft to Christian missions. See this handbook, U.S. Declaration of 76, Section 9, and comment. Because such donations make no law, these do not violate Amendment 1. Section 4, Clause 1, the United States shall guarantee to every state in this union a republican form of government, and shall protect each of them against invasion, and on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. Comment. Do not try to wring more from this republican form clause than it holds. It requires the United States shall, that the general government ensure each state has a republican form of government. Note well, it is the form that the general government is to ensure and no more. Federal meddling with the inner workings of the state government is off limits. In a republican form of government, the people elect the representatives to a legislature for purposes of fair taxation and to declare, if necessary, war. However, our Constitution's chief purpose for ensuring to each state a republican form of government is to ensure the staying power of the general government of Washington, D.C., by first ensuring that each state seats a state legislature, so that the most numerous branch of each state legislature can choose senators to send to the U.S. Congress, and second, ensuring that each of the several states sends representatives and senators to the U.S. Congress. In addition, the following 4 observations are noteworthy. First, the Supreme Court says Congress, not our courts, must decide whether a state government is republican in form. Congress holds that by seating a state's senators and representatives, it recognizes that the people of the state have duly elected their senators and congressmen, and thus that state's government has a republican form. Second, this clause requires the general government to protect each state against invasion. This power running with each state's power to protect itself by calling out to muster its militia. Third, a state's legislature can request help from the general government to put down riots or other internal violence. A state's governor, however, rightfully makes such request only if the violence is keeping the legislature from meeting. This clause, by requiring the president to get a state's legislative consent before using national force against domestic violence within that state, limits his power. Using this constitutional principle, even county sheriffs have required notice before allowing federal action in their counties. During the Pullman strike of 1894, President Cleveland sent national troops over Governor Algeld's objection into Illinois, saying the strike threatened future movement of the U.S. mail. The troops killed 13 people. In 1957, President Eisenhower put the Arkansas National Guard under his command and removed it from command of Governor Faubus. Outside our Constitution, the phrase republican government is used in 2 ways, the common law sense and the civil law sense. The common law and constitutional sense refers only to that form of government that elects legislative representatives that are independent from the executive and judicial offices. By contrast, the civil law sense refers to unlimited power of the majority, such as the Greeks' republicanism. See Brent Allen Winter's Excellence of the Common Law, Application 9, discussing 17th century England's view of republicanism. The Latin term republic joins res, a matter of, and publica, the public or the people, thus a matter of the people. Indirect majority will through power, indirect majority will through power elections, through popular elections of representatives, distinguished from democracy, the people's business by direct popular vote. Montesquieu, for example, held the ancient Greeks' civil law sense of republicanism, used the words democracy and republic interchangeably, advocated common ownership of property, as in the Republic of Plato, and praised Lycurgus, the legislature of Sparta, for removing reward for ambition, giving natural affection no outlet, because a man was neither son, husband, nor father. The state, said Montesquieu, instead of citizens, establishes commerce. Our Constitution recognizes the fundamental superiority of the common law tradition over Greek republicanism because provides greater stability for a country through its stressing of relationships and the dignity of individual freedom, both of which Greek democratic republics, being of the civil law kind, still reject. In 1954, even Congress, seeing that the word republic in the American pledge to our flag gave tacit approval to the civil law's communist republics, added the phrase under God after the words the republic for which it stands. The colonials, contrary to Greco-Roman republicanism, held fast to the common law principles that Stephen Langton wrote into Magna Carta 1215, and experience had tempered. Hence, our American tradition of law and government is not a never-before-tried idea. Our Constitution intends republicanism only in the sense that the people send representatives to form a legislative body, foremost to ride herd on governors and presidents. Since such indirect legislative representation is through a majority, Fortescue called it the only political feature of common law government, distinguishing it from civil law government. For example, civil law governments of the Greco-Roman republics, so-called, use no representatives to limit taxation. Simply put, our common law government neither descended from the Greeks nor did our founders model it on any Greek theory of republicanism. To be sure, they cited the Greco-Roman styled republics not for examples follow, but to avoid. In fact, says the Supreme Court, the framers breathed the air of the common law. The framers of our Constitution were born and brought up in the atmosphere of the common law, and thought and spoke its vocabulary. When they came to put their conclusions of fundamental law in a compact draft, they expressed themselves in terms of the common law, confident that they could be shortly and easily understood. Consequently, the language of the Constitution, says Chief Justice Taft, cannot be interpreted safely except by reference to the common law. The founders, however, confronting civil law doctrines then afoot in Europe, sometimes referred to our form of government as a republic, using this term because of its popularity during England's struggle with the crown over a century earlier. The colonies' determination to keep their English common law and government, however, embroiled them in a life and death struggle with England, the mother country. Consequently, many of them were down on anything labeled English. In fact, the phrase English common law aroused misplaced disgust among the colonials against the common law, the very ideal they were fighting to keep. A few decades later, in early 19th century America, resentment against all things English, especially the common law, even fostered an emotional charged and powerful faction out to replace the common law with civil law. To sum up, due to the colonials' growing distaste of all things English, the word republic became preferred to English common law, or even common law. In our Constitution, the word republic does not denote a government's inner workings, but that it uses representatives. Bottom line, courts hold that Congress, by seating the senators and representatives any state sends, provides conclusive evidence of that state's Republican form of government, and thus bars the general government's intrusion under the Republican form clause. See this handbook, U.S. Declaration of 76, sections 825 to 29, and comments. All right. And that was Brent Allen Winters. Moving forward again in his Declaration of 76, United States Constitution, common lawyer comments, clause by clause. And we will see you on the next call. Peace and love.